Welcome to this series of short podcasts on the Modern Slavery Act, brought to you by the Justice Hub at the Wilberforce Institute, University of Hull. Together over this 7-part series, we'll be taking a look into key provisions of the Modern Slavery Act 2015, what they mean, and exploring how they are applied in practice. Hello, my name is Andrew Smith. I'm the manager of the Justice Hub at the Wilberforce Institute at the University of Hull. I'm also the coordinator of the Humber Modern Slavery Partnership, a post funded by the Police and Crime Commissioner for Humberside and hosted here at the Wilberforce Institute. Here at the Institute, our mission is to advance fundamental knowledge of slavery and emancipation, to inform policy, business practice and public debate at local, national and international levels. We have a passion for research that aims to inform practice and policy. We have important research collaborations with the Salvation Army and the Modern Slavery Policy and Evidence Centre, to name just a few. If you enjoy these podcasts, please do head over to hull.ac.uk/Wilberforce to find out more about our work, our programme of public lectures, research projects and much more. These podcasts will be available on our Wilberforce YouTube channel. You can also follow us on Twitter, Instagram and Facebook to keep up to date with all things Wilberforce. In this first episode, we will take an introductory look at the Modern Slavery Act, why it exists, where it came from, and what it really means in practice. We are only just beginning to uncover the true scale of this despicable, serious and organised crime. The impact on victims is often that of complete devastation, leaving many destitute and even more vulnerable than before. As professionals, we have a duty to ensure that not only we bring perpetrators to justice, but that we are best prepared to identify and support victims to a meaningful and lasting recovery. Legislation and policy play an instrumental role in how we are able to respond to crime and social injustice. Policy should drive action. It should guide us towards collective outcomes that reduce crime and make our communities safe and secure for all people who reside within them. Legislation is the political and legal tip of the spear that makes disrupting organised crime possible. It sets out what we must do to protect victims. It imposes statutory duties and frames the legal landscape so that law enforcement and criminal justice can effectively and correctly bring perpetrators to justice and also protect those who have been exploited and safeguard those at risk. The Modern Slavery Act was introduced in 2015 to give law enforcement the tools to fight modern slavery, ensure perpetrators receive suitably severe punishments, and enhance support and protection for victims. It consolidates several previous slavery and human trafficking offences and introduces new preventative measures, support systems, and even a regulatory body. The Act makes provisions for victims, for professionals and practitioners. It informs policymakers and sets the tone for how we measure success. So where did it come from? In 1803, Denmark became the first sovereign state to legally abolish their slave trade. 4 years later, in 1807, both Britain and the United States enacted legislation following suit with the Act for the Abolition of the Slave Trade and the Act prohibiting importation of slaves, respectively. In the UK, it was not until 1833 that slavery was legally abolished throughout the British Empire under the Slavery Abolition Act of 1833. If we jump through the decades to the 1930 Forced Labour Convention, then onto the 40s and the Universal Declaration of Human Rights, which said no one shall be held in slavery or servitude. Slavery and the slave trade shall be prohibited in all their forms. Onto the 50s and the 1953 European Convention on Human Rights, which stated no one shall be held in slavery or servitude. No one shall be required to perform forced or compulsory labour. We jump now to the year 2000 and the protocol to prevent, suppress and punish trafficking in persons, especially women and children, also known as the Palermo Protocol. The protocol was adopted by the United Nations General Assembly in 2000 and entered into force on the 25th of December 2003. As of May 2020, it has been ratified by 178 parties and gives us the definition of trafficking in persons we use today. Let's then jump to 2015 and the Modern Slavery Act as we know it. At its inception, it was hailed as a groundbreaking, world-beating piece of legislation brought in by then Home Secretary Theresa May. On the 26th of March 2015, she had this to say: "The presence of modern slavery in today's society is an affront to the dignity and humanity of every one of us. The Modern Slavery Act 2015 is a historic milestone. This landmark legislation sends the strongest possible signal to criminals that if you are involved in this vile trade, you will be arrested, you will be prosecuted, and you will be locked up. And it says to victims, you are not alone. We are here to help you." Since 2015 and its inception, there have been 2 independent reviews of the Modern Slavery Act to date. The first by Caroline Hockey QC, called the Modern Slavery Act Review, and in July 2018, the Government commissioned Frank Field MP, Maria Miller MP and Baroness Butler-Sloss to undertake an independent review of the Modern Slavery Act. The review considered specific provisions in the Modern Slavery Act, such as the role of the Independent Anti-Slavery Commissioner, transparency in supply chains, independent child trafficking advocates, and the legal application of the Modern Slavery Act. The Modern Slavery Act has given us many new provisions, such as the Anti-Slavery Commissioner, independent child trafficking advocates, the statutory defence, transparency in supply chains, penalties and sentencing provision, and reparation orders or duties to support victims. Here is a quick overview of some of the provisions we will be covering in this series. Part 5 of the Act covers the protection of victims and makes certain provisions, such as Section 49, which covers guidance about identifying and supporting victims. This statutory guidance is aimed at competent authority staff in any part of the UK who may make decisions on whether or not an individual is a potential victim or victim of modern slavery for the purposes of the National Referral Mechanism. It gives guidance on the indicators that a person may be a victim of modern slavery, the support available to potential victims, the decision-making process for determining if someone is a victim, as well as how to work with adult and child victims. It gives guidance on trauma-informed practice and the role and responsibilities for those who have a statutory duty under this guidance. The National Referral Mechanism is a framework for identifying and referring potential victims of modern slavery and ensuring they receive the appropriate support. The people who can make a referral to the NRM are known as first responders. Referrals are made by designated first responders to the Home Office. This is the beginning of the NRM process for a victim. Running in parallel with the NRM is the Victim Care Contract, which is run by the Salvation Army. The Victim Care Contract is a mechanism of care and support for victims and potential victims in the UK. Next, in Section 45, under Part 2 of the Act, we see a defence for slavery or trafficking victims who commit an offence. Potential victims of modern slavery may be suspected or accused of committing criminal offences. Section 45 of the Modern Slavery Act provides a statutory defence for adult and child victims who have been forced, threatened or deceived into committing certain crimes by their exploiters. The defence does not apply to the most serious crimes, such as sexual offences or offences involving serious violence. Guidance by the Crown Prosecution Service outlines the crimes that do not apply to this defence. The defence or an allegation of forced criminality may be raised by the defendant at any point in the criminal justice process, from the point of arrest, including during trial proceedings. It is imperative that our criminal justice system have a good working knowledge of the Act for this very reason. Many victims of forced criminality do not disclose at the point of arrest that they have been forced to commit these acts. Staying with Part 2 of the Act, Section 48 gives provision for independent child trafficking advocates. The role of child trafficking advocates is to provide specialist independent support for trafficked children, in addition to existing statutory service provision, and to advocate on behalf of the child to ensure that their best interests are reflected in decisions made by public authorities. Despite successful early trials and a promised rollout in 2016 by the Home Office, the service is still only represented in 19 areas of England and Wales. A child trafficking advocate must be invited to take part in all meetings and discussions which relate to and impact on the child, such as those with local authorities, the police, immigration authorities, and those which may take place within the criminal justice system. The impacts of exploitation on children can be profound and life-changing. The trauma suffered in prolonged trafficking cases is severe, and the support required is nearly always complex and extensive. The role of child trafficking advocates is to help them navigate these complexities and ensure they have fair access to their rights and entitlements. Part 4 of the Modern Slavery Act created the role of the Independent Anti-Slavery Commissioner. The Commissioner has a UK-wide remit to encourage good practice in the prevention, detection, investigation and prosecution of modern slavery offences and the identification of victims. The Commissioner is accountable through her strategic plan and annual reports, which the Secretary of State lays before Parliament, setting out the extent to which objectives and priorities are achieved. The Commissioner may request a specific public authority to cooperate with the Commissioner in any way that the Commissioner considers necessary for the purposes of the Commissioner's functions. The Commissioner and its office can undertake or support the carrying out of vital research that supports the anti-slavery sector and its response to victims. It also plays a vital role in providing information, education and training. Part 6 of the Act regards transparency in supply chains. Section 54 requires businesses with an annual turnover of 36 million or more to publish a slavery and human trafficking statement, commonly known as a modern slavery statement, every year. A very divisive part of the Act that many critics argue does not go far enough to combat slavery in supply chains. Organisations are not required by the Act to implement any strategy to combat slavery in their supply chain. They are well within their rights under current legislation to publicly state that they are doing nothing to combat slavery within their supply chain. According to the recent TISC report, there are 5,448 UK companies that are required to comply for which they could not find a statement. Although there is a threat of an unlimited fine for non-compliance, 7 years after the introduction of the Act, no companies have received a fine. Thank you for listening to this podcast by the Justice Hub at the Wilberforce Institute. I hope you enjoyed this summary of the Modern Slavery Act 2015. In our next episode, we'll be diving deeper into Section 45, the statutory defence for victims, and just how this legislation really works in practice. Thank you for listening. Take care.